Hi, I'm Debbie Moraes. This is Legal Matters, the program that's been designed to address critical issues facing consumers and businesses today. It's legal information, practical solutions, and straight talk about a wide variety of issues that will affect your home and work life. Today, a continuing issue that plagues many of you, that is a housing foreclosure. Rhode Island has a new state law that just might have been good news for homeowners, those who are in trouble. In view of the tide of foreclosures that are still sweeping the state, the Rhode Island government had enacted a new law requiring something called mediation before foreclosures could proceed. Sounds good. It's been in the news. It's been designed to eliminate some of the confusion between, or confusion across the state, I should say. So we're going to discuss mediation law as it pertains to Rhode Island pending foreclosures today, the process, the exemptions. There are many details. So to help us understand the details, we have our attorneys, who are also mediators, I should say, Jackie Grasso and David Bazar, from the new partnership of Bazar Grasso Law Firm, still located in East Providence. Okay, so from what little I can grasp of this at the moment to explain, there's something that started in 2011 to try to bring together the borrowers and the lenders and to avoid them losing their homes. Sounds very good. And we know that there were problems with banks who were unscrupulous and sloppy, and then we had stupid or perhaps just unfortunate borrowers. They got in a jam. Now they're trying to work this out so that people can stay in their homes. How did this all play out, and what's the story of that mediation law?
Well, because of the rise in foreclosures over the last several years, as you say, the lenders are being scrupulous and just going into foreclosure without properly notifying individuals. In March of 2010, there was actually a foreclosure counseling provision of the law that was added. And what that says is that within 45 days prior to initiating a foreclosure, the bank or mortgagee must notify the borrowers that they have the availability of receiving counseling from a HUD-approved counselor. That law was then followed up by a second section of the law, which was signed by the governor in July of this year, which required a mediation conference. So the first part just advises you that you have the availability to go through counseling through Rhode Island Housing or a HUD-approved mortgage counseling agency. The second section now requires the mediation provision, which basically says if the loan is not more than 120 days delinquent, before the bank can initiate foreclosure proceedings, they must, and I reiterate, they must notify the borrowers that they have the ability to attend a mediation conference. And that has to be done within 45 days of receiving the notice. The reason for that was there was much confusion across the state about mediation, and different cities and towns had enacted their own ordinances. For instance, Providence had a city ordinance which the banks did not like that required this very thing, mediation conference. Then East Providence followed up, Warren, Cranston, and Warwick. So what the General Assembly did is they basically provided a uniform standard of a mediation law so that all the cities and towns would comply to this. So this one takes precedence of all these city and town ordinances.
So initially, when this conference was supposed to be called, who triggered such a call? Was it someone who was the 120 days of being delinquent, or could you have been 60 days, or did you have to be 6 months? Was it, based on the city you lived in, that each one gave you a little more leeway?
Yeah, every city was a little different. So now what the General Assembly has done, they passed this law, which became effective the 12th of November of this year, basically says if you're not more than 120 days delinquent and before foreclosure initiations can begin, they have to give you written notice. And part of that written notice is to identify the homeowners, the lot, the plat number, of course the address. Also identify a representative from the bank with a telephone number, and to let them know that a mediation counselor will be contacting them. For now, the mediation counselor is someone from Rhode Island Housing, and they will be contacted by a mediation counselor and schedule a meeting within 45 days of the date of that letter.
So
go ahead.
Just to make a little distinction on some of the issues that might be confusing, you said Jackie and I are mediators, and we are at the beginning of the show. That's something you had mentioned, that we can mediate almost everything except these types of things. These mediators have to go through the process of HUD and be HUD employees.
Yeah, part of the law indicates who can be a foreclosure mediation counselor. So you have to have education in mortgage counseling, and familiarity with the law. But for now, until the Department of Business Regulation decides otherwise, the law says that it's going to be someone from Rhode Island Housing. And also, the borrowers need to know is that this is free to them, and the law provides that the mortgage companies have to pay the mortgage counselor or the agency $500. So it's not going to be met with too much.
It's not been well received.
Correct.
And the other thing I wanted to distinguish is people may have seen in the paper there's a federal mediation program, which is much different than this. Those are cases that are in federal court, and the federal courts have appointed folks that are the mediators for those cases, and those are really limited to the cases that are already filed in federal court.
You're referring to in Rhode Island, Merrill Sherman, who's the special
court-appointed, special master for the mediation.
And I think what happened in federal court is a lot of homeowners filed actions for either RESPA violations or wrongful foreclosures.
Right.
And in the state law, if they proceed with foreclosure without filing a certificate that a mediation conference has taken place, then it's a void. It's void. The foreclosure is void. So they have to not only schedule a conference, have the conference. If they reach an agreement, it has to be in writing. The agreement can be something like a loan modification or a workout agreement. It has to be in writing. And if the borrower does not comply within 12 months, then the mortgage company has to file a certificate saying that they haven't complied, that the mediation has proceeded, and then the foreclosure can proceed. And then that certificate has to be filed with the foreclosure deed. So it's backtracking.
That's a mouthful.
It's a lot. It's a very detailed regulation.
And of course, nothing goes as simple as it could or should. I understand that there are a couple of exemptions, and for those people who, number one, I guess, were beyond the 120 days, if you didn't pay your something in 3, 4, 5, 6 months, the banks or the servicers, or whatever they call them, the agents, are able to close you down and not even go through this process, right?
And that's a concern because, well, the banks use that as a mechanism to avoid the mediation requirement. That's a possibility. I would like to think that that was not the intention of the General Assembly when they passed the law, and I would think any lawyer that's advising a bank or mortgage company would tell them, regardless of the amount of days behind, if it does exceed 120, to still comply with the law, because it can always be challenged. And oddly enough, Banking Regulation 5 for the Department of Business and Regulation mirrors this. However, their regulation says that the notice can go out if it's less than 90 days. So there is a difference between the state law and the banking regulation. Banking regulation says 90, state law says 120. Either one, I would think that the mortgage companies would at least comply and not wait the 120 to circumvent the law.
But of course, one could argue that even though foreclosure is much more expensive, a lot of these lenders, they have a vested interest in perhaps kicking someone out. Foreclosed properties, now that the economy is going up, they have a better chance of selling the properties and benefiting. That's not very kosher, perhaps, but we've been hearing that yet is another potential abuse. Can you comment, or what's your thought about that?
Well, I can tell you, as sitting as a municipal court judge in Johnston, and David can also agree with this, because the banks have foreclosed on properties, they have not followed through on having the properties comply with local ordinances. And what I'm seeing in municipal court are properties that have become run down. The cities or towns have condemned the properties. They're fining the banks by the day because they're basically, uninhabitable, and the banks are not really selling them as quickly as they should be. They're not complying with any requests by the towns to rehab the property or at least bring it up to code so that it would be livable. I mean, in some cases, we had to board up houses in Johnston because rats were running in and out of it, people were breaking the windows, and the bank just let it sit there like a potted plant.
I have one case in front of me in East Greenwich. It's not that bad, but it is a house that's been vacant because the homeowner was foreclosed on, or at least she thinks she was, and the bank hasn't maintained the property. So part of the issue is we noticed, or the housing inspector noticed the homeowner because that's who it was registered to, and I told them we have to actually have the solicitor do a title search to check, did the bank foreclose, and did they do so with notice to her so that she's no longer the owner, and the bank now has got to be noticed to come in front of me, and as Jackie said, this is common in many areas where the bank's not maintaining properties, and they'll be subject to fines for doing that, just like any homeowner
And
would.
they hefty fines. We have one bank that was fined up to $40,000, and they're paying it. You know, I hate to say it's a revenue source, it really isn't, but what do you do to get them to comply? Once a bank does foreclose, they now have to file the foreclosure deed, and along with that, a certificate of compliance of mediation program. And what I failed to mention is that these notices have to be in English, Spanish, or Portuguese, so that it at least tends to non-English speaking people.
And to go back to your other part of your question, which was, well, the economy is getting a little bit better, property values are going up. It's still expensive for a bank to foreclose on a piece of property,
Surely.
maintain the property,
Surely.
if they don't maintain it, to pay the fines in municipal court, and then to go out market and sell the house. Whereas if they go through mediation or work out some kind of arrangement with the homeowner who's already in the property, some kind of modification where they get their money eventually, many banks, I think, in the long run would be better off still, even though the market is getting a little bit better, working out deals with the people who are there so that they can stay in the home and maintain the home, and the bank eventually get its money.
Makes sense.
I think Providence initially enacted the ordinance because they were having a majority of the foreclosed homes, they were having properties that were being vandalized. They had a problem with squatters, and it became such a problem that they said, and the other objective obviously is to keep people in their homes. Because it's always better to keep people in their homes, and if there's a way to avoid that, better for everybody. Somebody stays in their home, what does that mean? They're going to continue to pay taxes.
It makes
the bank
sense.
may get paid.
Well, obviously they'll get paid, yeah.
It makes sense that the banks should have always been operating on good faith and trying to keep someone in the home. It certainly makes sense all around. But now, even if they do go into some mediation, I understand that the banks still could say, thanks, but no thanks. We find this unacceptable.
Correct.
For, I guess they have to have some supposedly legitimate reasons to do this.
Yeah, there's a good faith requirement in the law. The conference has to be scheduled within 60 days of the date of the notice going out. All parties have to cooperate, okay? And the bank does have the ability to reject whatever type of proposal is presented before them, because if somebody quite simply doesn't have the income to pay on a modification or a mortgage workout, then it is what it is. If the bank's going to reject that, they have to notify the borrower in writing. Again, they have to file a certificate of compliance before they can proceed with the foreclosure. The certificate has to be filed along with the deed. But yeah, there's a good faith requirement. There's also a good faith requirement on the part of the borrowers. So if they don't attend the sessions, then there's not much more they can do. I mean, if the coordinator, I believe they have to make at least 2 attempts to contact the borrowers. If they don't respond or if they miss a session, then the coordinator files a certificate of compliance, sends that to the bank, and then they can move forward with it.
I understand there was one other exemption that we didn't address, and as I read about it through the journal, that the other exemption that the mortgage had to originate in the state of Rhode Island as opposed to...
I think what that is if it's, we call them portfolio loans. So for instance, what's Rhode Island Bank? Bank Rhode Island. If the mortgage originated in Rhode Island and it stays in Rhode Island, it's not sold off to some bank in East Idaho, then that is an exemption as well. The theory behind that is you have counselors available to you right at your doorstep. okay, because the bank is located in Rhode Island, all the offices are in Rhode Island, the mortgage is on a house in Rhode Island. And by the way, what I forgot to mention is this law only applies to individuals who live in, whose house is their primary residence. So for single family up to four family houses, anything beyond that, there's an exemption from the law.
You pointed out something earlier, David, about a case that you were handling that someone didn't actually know whether or not they were foreclosed upon. How does that actually happen? And if they didn't really know, is it worth their while to go to a lawyer and find that out first, perhaps mediate that not as the context that we're speaking of here, but in just handling their languishing bills? What should happen, and how does that happen, David?
So in that case, the alleged homeowner, as far as the town was concerned, came in and she said, I don't know why you're bringing me in. The house was foreclosed on. And the town representative said, not according to the land evidence records as I reviewed them. I don't think they ever went forward with the foreclosure. Apparently they sent notice to her. They started the process, but according to the town official, they never finished the process or filed all the complete paperwork. So what I did in that case is I suggested to her, if that's correct, you should go back to your attorney, because she had an attorney who was representing her, have him check it and find out what the status is, and perhaps you still own the property and you should know that. That's coming back to court in a couple of weeks, so we'll see what happens with that.
And what's going to happen with that is if the bank hasn't proceeded with the foreclosure, any violations are going to be her responsibility.
Right, that's why we told her to go back to her lawyer and find out.
Yeah, and the violations can be hefty.
Right.
The cities and towns can charge her fines.
Right, but the judge in East Greenwich is very reasonable.
He's
so.
very reasonable. So is the judge in the town of Johnston. Correct.
You were talking about fees before. I understand in reading about Meryl Sherman and what she's dealing with that she's collected a hefty sum from these borrowers who are in arrears, supposedly cases that are still active, likely to be foreclosed on, they haven't been. She's collected a boatload of money. Some has gone out to the bank, some go to fees. If someone is paying their mortgage, which is how she's derived that income, wouldn't that or shouldn't that automatically stave off foreclosure? Because definition of foreclosure, you didn't pay your mortgage and we're going to collect the house.
Well, look at the promissory note in the mortgage or any mortgage. If it says you're supposed to pay $1,500 a month and you pay less than that, then they're going to take that money and they're going to put it in what's called the suspense account because it's a less than minimum payment. Sometimes what people do is if they're like 90 days or let's say it's 6 months behind, and they've received the appropriate notice of foreclosure, if they try to send a payment, even one payment, the bank will send it back.
Oh,
and the bank will send it back with a letter saying your house is, your mortgage is in default. Of course, they need to be notified that there's a default before they can proceed with foreclosure. They'll send it back. Instead of keeping it and trying to work it out with the borrowers, they just return it. And they'll get a letter saying, you know, it's been forwarded to this law firm for foreclosure proceedings. And that's what happens a lot. I've had so many clients who have been to my office and said, I tried to pay it, they returned my money. So at some point they just throw their hands up, they give up, say, not going to take my money, then fine, you know, which really, it's unfortunate.
And the money that she has collected for fees for the program, actually, when you break it down on a per-case basis, is not all that much. It's not like she's being paid an outrageous sum for each case and the bank isn't receiving anything.
Yet I understand, too, that despite her attempted good work, that there are a group of lawyers who are now fighting this, saying that there's no ending term to how long this process is going on and it's costing money. And so I guess they want to sort of squelch this injunction?
Well, I think there's some different issues there. There's the issue as to when is this program going to end and how many times will people go through it and what's the cap, if there is a cap or if there's no cap, do they have to pay forever? And those are some legitimate concerns that they have. But I don't think they have a concern about what the mediation office was charging per case. It's just, is there any end in sight and when can we expect this to finish?
So I guess she was trying to change what the per case fee was. And then, I guess I have to bring this up too because you're lawyers. There's an issue too about, isn't this just swell for lawyers? Because now lawyers are getting paid not for the borrower, because I understand, as you've explained it and as I've read elsewhere, that the borrower is covered,
no cost.
but not necessarily is everyone else.
Well,
No,
I don't
the banks,
think
yeah.
that's exactly how the federal program works.
Is that true for Rhode Island too, is the question?
Well, what's happening in Rhode Island is you need a representative of the bank, you don't need an attorney. So whoever that agent is that is identified in the initial mediation conference letter, that's the person that's going to be the contact. That's the person who's going to be the go-to person. So the lawyers are not even going to get involved at this point unless there's some legal paperwork to sign, but when it's at the mediation stage, then it should only be an agent or representative of the bank.
When you went through that litany, which I suppose there might be some value in highlighting some of the key points again, was that set up to be more onerous for the banks that are holding these mortgages because they had been so sloppy in the past? When I looked at it, it says the responsibility of the mortgage company. It just seemed like everything was on their side of it.
If you read the actual language of the bill, part of the purpose was that, but I think the main objective was to keep people in their homes and to stop any foreclosures that have been conducted wrongfully. So, yeah, that is a theory behind it, but...
And it's easier
it's with the consumer in
for the
mind.
legislature to think that if they create this rule and this law, that the banks will figure out how it works and how to operate within it than an individual homeowner. So by putting some of the burden back on the bank who wants to foreclose, what they're saying is, you want to do this, you have to follow the process. And we're going to put the burden of following the process on the bank rather than on the homeowners who might not even know this law exists.
And it's a state law, so that's going to take precedence than a bank saying, well, what do you mean I have to comply with an ordinance from the city of Providence?
Right.
You know, what's your theory behind that?
What's your jurisdiction
Yeah.
to regulate us, whereas the state can regulate banks?
The only unfortunate part of this law is that it's only good for 5 years. So the law terminates in July of 2018. What's going to happen after that? I would hope that before the expiration date, the General Assembly would file another bill to extend that.
But should that actually be necessary if they're saying that there are, in Rhode Island, 744, maybe fewer now, I don't know, active cases? How long does this go on? Shouldn't 744 cases be resolved in the next 5 years if they are trying to go through this process?
Well, that might be the amount of cases in federal court.
Federal
We
court,
have no
not
idea how
necessarily
many foreclosures are pending.
And there's two theories.
Yes.
One theory is that hopefully, as the economy gets better and people have jobs and can pay their mortgages, that there are less foreclosures in the future and that we get back to a more stable environment. So that's probably why they have the sunset law in this, because if everything resolves and now it's just the standard, you know, whatever number of foreclosures we had before the economy crashed in '08, then they won't need it anymore. As opposed to, if it's still bad, we have a lot of laws that have sunset provisions in them where they just simply, before they sunset, pass a law saying we're going to extend the bill.
I would think it should just be a law period without any termination dates. But
So considering this is meant to help consumers stay in their houses, what's the advice or the caveat that you would give to borrowers who now have something to rethink? They now have, I don't know if I want to say it's a golden parachute, it's just an opportunity here if there's mediation. So what would you advise someone who's lucky enough to be involved with the mediation process? What can they do to help themselves or help the bank help them?
well, they need to gather all their personal information, because the bank is going to require probably another application, which means they'll have to produce pay stubs or proof of income from whatever other source. They'll have to produce tax returns, a list of personal assets. So they just, like they're applying, treat it as they're applying for another mortgage.
But what I hope the mediation process does is, because there are these other modification programs and these things where the banks have a process that never seems to work for most people.
Yeah, it takes forever.
And they make you jump through hoops and then you miss a hoop. I hope the mediation process keeps the banks feet to the fire too, that if the people do X, Y, and Z, whatever it is that is being asked, that the bank now has to really take a look at it instead of just automatically saying no or not agreeing. The mediator maybe can look at the banker, the representative in the eye and say, you know, this is what you asked, they did it. Now the ball's in your court to come to an agreement.
And by the way, the representative from the banks have to comply with the request from a coordinator for information. They have, I think in the law it says they have 2 weeks to provide any information to a mortgage a mortgage mediator from the date of their request. They have 2 weeks.
Because the big complaint that people have
they
is...
never respond.
Exactly.
Yeah.
Banks don't respond. You get put on hold. You're sent from one place to another.
Yes.
You can never get back to the same person. So hopefully this eliminates a lot of the communication problems that people end up having in trying to work out their loan modifications or to stay in their home one way or another.
So for someone who's in this process of mediation, and you just gave us some excellent advice about what the homeowner needs to do, if he had for a while been out of work, which could have caused that default, as you indicate, if he now has, or has since, obtained a job, even if he couldn't send in that mortgage payment and it wasn't acceptable, does he now, if not get an entirely clear slate, does he now have a reason to rally, save the money, do what he needs to do so that he could get back in a HARP or some sort of refinanced mortgage program? Is that likely to happen, or does someone, once they get in that mediation process, they just say, here are my bank stubs, but I missed 6 months of payments or 3 months or whatever it is?
No, the objective is to have some type of mortgage workout agreement. So maybe what the bank can do, one of the suggestions would be as a mediator, have the bank take the arrearage and tack it onto the back of the loan, so that they're not looking for the arrearage over the course of 12 to 24 months, which is only going to increase their monthly payment.
Right.
That doesn't work if you have limited income, if you're living paycheck to paycheck. In the old days, that's what we used to do, a mortgage workout agreement. Take the arrearage, pay it over the course of 12 to 24 months. And if that didn't work, you can go into a Chapter 13 and pay the arrearage back. However, yeah, the objective would be to try and modify the loan and not make it so burdensome on them financially.
It does sound like that there is a possible solution
Yeah.
that there was not before. So if anybody had been in the process before where they thought they were going to be bankrupt, they're not sure, they stopped paying bills and perhaps didn't see a lawyer, one of you or others, who could help them work something out, at least you're giving them some hope about they could move on without necessarily being subjected to unreasonable monthly payments, which I think, from what we've read, is very frustrating for someone.
Yeah.
Now that I'm back on my feet, if you take that much more money, I won't be able to do it. So you're saying there's hope with that.
Yeah, there are things that people have no control over. For instance, their taxes may go up significantly. They don't have any control over that. You have to pay the tax man. It has nothing to do with the mortgage company.
Right.
So
You have to budget appropriately.
And as Jackie was talking about, people who have been trying to make payments and they don't accept them, I would set a bit of that aside, not just spend it in case you come to a situation where you can reach a deal with the bank and they want a little bit up front. Well, yeah, I've saved that because you didn't accept my payments and I have it available.
Yeah.
Okay. And in the very little amount of time that we have left, is there anything that you would say about this proposal that is wrong-headed, as some in the media have said? It's just not helping the real estate market. It's continuing to prolong a sickness. Yes, no?
I don't know that it's going to prolong a sickness. I think it's going to make it much more difficult for the banks to proceed with foreclosure and ultimately put place in
I think it helps the real estate
market.
market if there are less houses in foreclosure.
It's going to create less of a problem for title attorneys, I can tell you that,
Good.
hopefully.
So we hope that this has been helpful to you. We hope that you're not in arrears or in foreclosure difficulty, but at least there's new hope. Thank you for tuning in to David and Jackie and Bazar and Grasso Law Firm, and this is Legal Matters. We hope that you will continue to stay with us as our discussion continues.